So hi there everyone, my name is Neil Howes and I'm a partner here at the Insurance Disputes Group in Mills and Reeve. My practice really is focused around professional indemnity claims and D&O claims, but I also deal with policy coverage disputes as well. This is the second of our bite-sized seminars, which are focused on the principles of insurance law. For those of you who tuned in last week, you'll have heard my colleague Andrew Tobin talking about the Insurance Act and the new duty to make a fair presentation of the risk. So today we're going to take that a step further and we're going to look at what happens when things go wrong. So we're going to be looking really at the remedies which are available under the Act when the duty to make a fair presentation is breached. So here's what we're going to cover in today's session. We're just going to have a quick look back at the position before the Act and the remedies that were available then. I'm going to talk you then through the new remedies available under the Act and how those work in practice. We're going to touch briefly at the end as well on contracting out of the Act and in particular what's allowed and what's not. And then we're going to finish with a Q&A session. So I'm going to be talking for about 15 minutes and then we're going to have a 15-minute Q&A. So it really is a bite-sized session today. At the bottom of your screen, you should see a Q&A box. So what I'm going to suggest is as we go along, if you've got any questions that you want to ask, please do put them in that box and we'll get to as many of them as possible at the end of the session. But before all that, I thought we would start today with a poll. The poll question is about connections, one of which has a connection with the Insurance Act. So the poll is, what's the connection between the Empire State Building, War and Peace, the gigantic novel by Leo Tolstoy, and the Apollo moon missions? So the options are, President Trump has tried to take credit for all of them. They've all inspired songs or pieces of music, or answer C, they all took less than 5 years to accomplish. So I'm going to, if you'd like to go onto the bottom of your screen and start voting now, and then hopefully we will be able to see what your poll results are. So if you'd like to start voting now, I'll give you a few seconds to do that. Wonderful. Just give you a second. Right, we're going to cut off the polling. Credit to all of you, by the way, who went for answer A. President Trump has tried to take credit for all of them. As far as I know, he hasn't, but let's be honest, that's not beyond the realms of possibility. The correct answer is answer B, that all of these momentous events have inspired songs or pieces of music, plenty of songs, of course, inspired by the Empire State Building and New York. The composer Prokofiev was asked during the Second World War by Joseph Stalin to compose an opera about the novel War and Peace. And in fact, Frank Sinatra's 1964 song Fly Me to the Moon was released during the Apollo missions and was in fact the first piece of music ever to be played on the lunar surface as well. Answer C, they all took less than 5 years to accomplish, isn't right, but it is our connection with the Insurance Act, because actually all of these momentous accomplishments took less than 9 years to accomplish. And in fact, it took the Law Commission 9 years to conduct its kind of review of insurance law, and then for Parliament to pass through into law the Insurance Act 2015, which then came into force the following year. So if you were being a cynic, you'd say that it took longer to do that process than it did to actually land a man on the moon. So let's start then today by having a quick look at what the position was before the Insurance Act came into force. So at that point, of course, the duty was slightly different. It was a duty of disclosure, not the duty to make a fair presentation of the risk. And there was only one remedy available to insurers if that was breached, and that was avoidance. In other words, the policy was treated as if it had never existed. It meant that insurers didn't have any obligation to pay claims, but they did have to return the premium to the insured if they exercised that remedy. Why was the law changed? Well, I think there was a feeling during the Law Commission's investigation that probably the law as it stood was weighted too heavily in favour of the insurers. So you could have a relatively minor breach of the duty of disclosure and a real nuclear option by way of a remedy. To try and avoid that, the other practice which had started to become more commonplace and which also caused its own set of complications was a process called data dumping. In other words, particularly large organisations, to try and make sure that they had disclosed everything that was material to the risk, were simply dumping huge quantities of data on insurers without necessarily presenting that in a clear way. So the whole thing then was all in all a bit of a mess. Thankfully, of course, the new Act has corrected that, and we now have a set of remedies which are prescribed by the legislation. So let's have a quick look at what those are. So the key question that the Act poses in relation to breach, and this flows through into all of the remedies, is: was the breach of duty to make a fair presentation deliberate or reckless? The consequences of that are twofold. If the breach was deliberate or reckless, then the insurer can still avoid the policy and also refuse to pay all claims. And under the Act, because the breach was either deliberate or reckless, the insurer doesn't have to return the premium anymore. In all other cases, the remedies, and we'll go on to those in a second, depend on what the insurer would have done had the duty to make a fair presentation been complied with. A couple of things to note on this before we move on. The question of whether the breach was deliberate or reckless is for the insurer to prove. So there is, if you like, a presumption that if there has been a non-disclosure and a breach of the duty, then that's either innocent or at the most negligent. Secondly, the Act defines what a deliberate or reckless breach is. So it's effectively a breach where either the insured knew of their duty and simply disregarded it, or alternatively, circumstances where the insured simply didn't care whether it was complying with its duty to make a fair presentation or not. Finally, it's worth mentioning that the test here is whether the breach of duty was deliberate or reckless, not whether the non-disclosure was deliberate or reckless. So my reading of the Act certainly is that you could have a situation where an insured has made a conscious decision not to disclose something, perhaps believing it not to be something that needs to be disclosed, and that's not a deliberate or reckless breach because the insured simply made an innocent or at best negligent mistake. So moving on then, we talked about just now about the remedies if the breach was not deliberate or reckless. And the Insurance Act then goes on to set out a kind of portfolio, if you like, a sliding scale of remedies that take effect in those situations. So on the one hand, for example, if the insurer would not have entered into the contract on the same terms, but would have charged a higher premium had a full disclosure and full compliance with the duty been made, then there is a proportionate reduction to the amount to be paid on claims. There is then a formula at the back of the Act which takes account of the premium that would be charged and basically spits out the percentage result in terms of what percentage of the claim has to be paid. Worth noting before we move on from that, that under the Act, the insured doesn't have the option of paying the increased premium that would have been charged, that the remedy is a proportionate reduction in claims payments. And the way that the Act is drafted suggests that that would apply to all claims made under the policy and not just one. In the middle then, you may have a situation where the insurer would have entered into the contract on the same premium, but would have imposed different terms. So for example, the insurer may have taken the view that had the duty to make a fair presentation been complied with, then it would have applied an additional exclusion to the policy, might have put an additional warranty in there, might have altered the excess provisions, things like that. In these situations then, the insurer is entitled to apply the terms that they would have applied had the duty been complied with. So for example, the insurer may come to the conclusion that it would have taken the risk, same premium, but it would have applied an exclusion, which in theory might exclude a claim which is now being made, and that would entitle the insurer now to reject that claim. At the top end of the scale, we've got situations where the insurer would not have entered into the contract on any terms had the duty been complied with. Now, in those situations, the Act prescribes that the insurer can avoid the policy in its entirety and refuse to pay all claims, but because the breach hasn't been deliberate and because it's not been reckless, the insurer has an obligation to return the premium. So all of this is very much focused on a subjective test rather than an objective one. In other words, it is all focused on what the insurer would have done had the duty been complied with. A common question that then gets asked is, well, are these remedies mutually exclusive or can they be applied in tandem? My view on that is, if the insurer's position is that it wouldn't have entered into the contract on any terms, then that is the remedy to be applied. But in theory, the other two could be used in tandem. So the insurer could say, well, actually, had we known about all of these non-disclosed matters, then we would have charged an extra premium, but we would also have imposed additional terms on the policy. And therefore, you've got a dual situation where the additional terms will apply, and obviously there would be a proportionate reduction in claims payments as well. A couple of things to think about in practice when considering these types of issues. The first is obviously focusing on whether the breach was deliberate or reckless. And that is very much your starting point under the Act. Everything flows from that. If the breach wasn't deliberate or reckless, then it comes down to what the individual underwriter, the insurer, would have done had a fair presentation been made of the risk. Now that is, as I've said, very much a subjective test. And for obvious reasons, you need to be speaking to the underwriter to work out exactly what decision would have been taken. There is, of course, a possibility that whatever position the insurer does take, then that might be challenged later on. And that is something for insurers to think about when kind of making their decisions. So how can you demonstrate what decision would have been made had the duty been complied with? And I suppose that's then, looking at reference to underwriting manuals, underwriting criteria, decisions that were made in similar cases, the underwriting process as well. What would have happened had the fair presentation been given? What's the process that would have been gone through, and how do you kind of justify and explain what decision would have been made? Before we draw to a conclusion, I just wanted to mention contracting out of the Act, because although this statutory regime has now been imposed, there are in certain cases options for insurers to contract out. The first thing to highlight here is that basis clauses, since the Act came into force, are now completely banned. Next week's session, which is going to be led by my colleagues Liam Burnett and Emma Harrison, that's very much going to focus on conditions, precedent and warranties and the impact of the Act on those. And they may well mention basis clauses. Basis clauses were basically a clause in the policy which elevated every single answer in the insured's proposal form to the status of a warranty. Now, the impact of that was that if any of the statements in the proposal form were factually incorrect, then that was a breach of warranty and that discharged the insurer from liability. And the good news for insureds is that under the Insurance Act, basis clauses are banned and there is no contracting out at all. In other circumstances, the insurer can contract out of certain provisions of the Act, and in theory could impose within the policy a different set of remedies to those that are prescribed under the legislation. But in order to contract out, the Act says that you have to comply with what's called the transparency requirement. That's set out in section 17 of the Act. What that effectively means is that the insurer has to take sufficient steps to draw the disadvantageous term to the insured's attention before the contract is entered into, and also that the disadvantageous term must be clear and unambiguous as to its effect. Now, we don't have any real case law on the Act at all yet, and so we don't, for example, know what approach the courts would take to the question of, well, what amounts to sufficient steps? But that is the test for contracting out that's applied by the Act. I should also mention in passing that the contracting out provisions do present a risk area for brokers, because obviously if an insurer is seeking to contract out, then it is the broker's duty to make sure that is brought to the insured's attention, and also to make sure that the insured fully understands what implications that potentially might have. So that is everything that we're going to cover today. I'm now going to stop sharing my slides and we're going to move on to the Q&A session, and for which I'm going to be helped by my colleague Andrew Tobin.
Thank you, Neil. Can we start with an emailed question, which is, are there likely to be more or less claims against brokers as a result of the Insurance Act? Okay.
So to put that in a little bit of context, sometimes the broker gets caught in the middle between the insurer and the insured in a policy coverage dispute. And there's a possibility that one of the reasons why a fair presentation hasn't been made is because the broker hasn't properly advise the insured on what that duty means and what the implications might be. So sometimes in these situations, you do see claims against brokers arise. My own personal view on this is that because we now have a greater range of remedies under the Act, we're probably likely to see claims awards against brokers drop, because there will be fewer instances where avoidance is the remedy and the insured is left completely without cover for a claim. On the other hand, there is, I suppose, theoretically a possibility in a rise in claims against brokers, but for lower damages awards, because you will have insurers applying these lesser alternative remedies. That said, the Act's now been enforced since 2016, and what we haven't really seen is a huge spike in claims against brokers. So that suggests to me that actually what is happening is that insurers are applying proportionate remedies sensibly, and also that brokers aren't really getting too much caught in the crossfire.
Okay, thank you. A question from Samantha. Are there many incidences of deliberate and reckless failure to disclose? And Samantha mentions claims, matters or circumstances. And she's also asked, and as has another question of Thomas Glaister, about the standard of proof for recklessness.
Okay, well, taking those things in turn, I don't think that there are any more instances of deliberate or reckless breach than there were prior to the Act. I mean, certainly prior to the Act coming in, there are instances where people have deliberately not disclosed something because they fear that it will have an adverse impact on their insurance or they won't get insurance at all. That has always happened, okay? It's rare, but it has always happened and it still happens now. But I don't think that necessarily we've seen a spike at all in deliberate or reckless breaches since the Act. In terms of the standard of proof that's applied in these cases, as I mentioned during the presentation, the burden is on the insurer to show that a breach has been deliberate or reckless, but the burden is on a balance of probabilities test.
Okay. I have a question from Thomas. How can the insurer prove that they would have applied an exclusion in a policy, presumably after a risk has not been fairly presented, when a claim comes in?
Okay, that's a really good question. I mean, ultimately it comes down to the evidence of the underwriter. But at the same time, of course, if the matter got to court, you would also expect the underwriter to be able to back up the position that they've taken by reference to their underwriting criteria, by reference to their kind of policy procedures, and the process for underwriting as well. So, you know, it is a very subjective test. It is all about what the underwriter would have done. But at the same time, I think the underwriter's position is strengthened if they can say, well, actually, I can also demonstrate that my decision to apply this exclusion would have been fully in line with the underwriting criteria that I'm working.
Okay, a question from Henry, which is, in the event that a wording is broker drafted and is disadvantageous to the insured, do we, and Henry is an underwriter, still have an obligation to bring this to the insured's attention? Or is that only when the insurers are drafting the wording?
Well, that's a good one. I think that there is still an obligation on insurers. I think that is what the Act prescribes, and you'll have to forgive me, I don't have my copy of the Act in front of me right now. But ultimately, it is the insurer's obligation, is my understanding, to make sure that the transparency test is met. And ultimately, the policy is a contract between the insured and the insurer, even if it's been drafted by a third party.
Okay, and then perhaps a final question for the live session, which is from an anonymous questioner. An insured submits a proposal form for 2020 in which they purport the size of their practice, I'm assuming this is a professional indemnity question, to be of a certain size, and then at the 2021 renewal, it turns out the practice for the previous year is much bigger than initially estimated. Could that be considered a deliberate failure of the duty of fair presentation? And if so, what would the remedies be?
Well, in theory, it could be, but then it comes down to whether the breach for the 2020 year was deliberate or reckless. So let's assume for the moment that the information about the size of the practice is something which should have been disclosed as part of the duty to make a fair presentation. I think you then need to look at actually the reasons for that mistake being made. Was it simply innocent or negligent? Or was there a deliberate or reckless disregard for the duty? And then in terms of how it impacts, then presumably it depends what claims have been notified during that 2020 year as to what remedies might be applied by insurers as a result of the breach.
Okay, thank you. There are a couple of other questions, but they are going over some of the ground you've already covered, I think, and perhaps you'd like to follow up with them afterwards.
Yes, of course. Happy to do so. Thank you, everybody, for attending. We're really enjoying putting on these kind of bite-sized webinars for you. We really value your feedback as well, and also ideas about new topics that you'd like us to cover. So we're going to keep the kind of broadcast open for a few minutes after we finish. So if there is any feedback that you'd like to give us, then please use the Q&A box as well. We'd love to hear your feedback. We'd love to hear new ideas about topics that you'd like us to cover. And don't forget that if you've enjoyed this and Andrew's previous session, then do tune in next week for our next webinar, which is going to be run by Liam Burnett and Emma Harrison, and that's going to be focused on conditions, precedents and warranties. Okay. In which case I'll sign off now, but as I say, please do leave us your feedback, and we look forward to catching up with you again soon. Take care, everybody.